All right, you go ahead and sign off then. All right, now there at the jail, who are you, sir? I'm sorry? All right, Harold Willis, all right? And you're his attorney as well, I believe.
I am, Your Honor.
All right. This is case number 22 CR 006, State of Ohio versus Harold Henry Willis. Mr. Willis appearing from the jail by Zoom. His attorney is Jacob Wagner. He is actually present here in the courtroom. We've had a mix of Zoom and in-person hearings here this afternoon. The assistant prosecutor, Adam King, is representing the state. The defendant is charged with 4 counts of rape, actually 7 counts of rape. This is a final pretrial. We'll have a trial date on May 9. Now I see that the state provided a bill of particulars and discovery. Have you provided your discovery yet, Mr. Wagner?
If I may, Your Honor, I have not. I've met with my client, if I may, sir, get ahead of myself.
Okay.
I've met with Henry multiple times, and in light of the seriousness of this case, we're looking at 7 life sentences, Your Honor. I'm still interviewing witnesses, tracking down people. A lot on my plate. I've spoken to my client, if the court would grant it, Your Honor, you are asking for more time to prepare. We already filed a time waiver at the inception, I think, of our first pretrial. Henry and I met over the weekend. He understands my request and he's in agreement. Just a lot to investigate, Your Honor. Maybe I need a agreement, Your Honor.
Well,
we did it orally and you wanted a written, so I went out and got it.
yeah, here it is, February the 22nd. Signed a time waiver.
Yes, sir.
All right. Well, originally it was set for trial on April 28th. Was after the time waiver. Actually, that was after the time waiver. Okay. All right. So you're requesting a continuance of the trial date? Or
Just the trial date, I think is.
Are you anticipating pre-trial motions?
No, Your Honor, no. It's a he said, she said.
All right. Okay. Has there been a written layoff provided?
I don't know about written, but I know we've spoken at length with the prosecutor's office. We're aware of what their offer is. I will say that on the record. It's not written, but I have.
All right. Well, at some point that will need to be reduced to writing then. All right. Mr. Willis, your attorney is suggesting that I don't know if you could hear what he was saying or not. Could you hear what he was saying? Okay. Well, he's asking for a continuance of the trial date, which is right now set for the 28th of April, to have more time to investigate and prepare your defense. And you signed a time waiver back in February to waive your speedy trial time because you do have a right under the law to be tried within 90 days of the date of your arrest if you're being held solely on this charge. Now, there are things that do extend that time, including filings of motions and discovery and so forth. And so actually, he hasn't been able to provide your discovery back to the state yet, so actually time has been told since the discovery request originally was filed. But any time that the case is continued at the request of the defendant, then that has to be charged to the defendant. And so if I continue this, it's probably going to be in June. We have heard of this in May. And so are you okay with that? You agree to the continuance and the understanding that it's going to waive the speedy trial time to the next trial date?
Yes, you are.
Okay. All right. All right, well, then the court will find that the defendant has waived his time orally, and I'll grant the continuance.
Thank you, sir.
We will set a new retrial for May 18 at 2 p.m. Trial date will be set for June 16th at 8 a.m. And the speedy trial time is extended pursuant to Revised Code 2945.72H on the defendant's request, as well as defendant's oral time waiver based on the record. All right, anything further from counsel? All right, thank you. All right, now, who else do we have in the jail, Ben?
Mr.
Thank you.
Yeah, Mr. Holt, Donnie Holt.
Donnie Holt, please. Are you Mr. Eidner?
Yeah, it's a seven.
Okay, we'll begin in just a moment here.
You got it. This is gonna be a plea, Your Honor, Mr. Cole.
Oh, okay. What about, yeah, Mr. Eidner's sentencing.
It's just, you got 10 minutes.
Yeah,
This
we'll about 15 or 20 probably. Be safe. All right, you're Donnie T. Holt. All right, this is case number 22 CR 70, State of Ohio versus Donnie T. Holt. Mr. Holt is appearing by video from the Justice Center. This is set up as a Zoom hearing, so he's appearing by Zoom. Mr. Wagner is actually present in the courtroom since he has other clients that are here in person. Do you think you'll need to talk with your attorney at any time during these proceedings? As we do, I can have you go into the jury room, get on the phone, and he can talk. All right. All right. Well, at any time you want to do that, you just tell me, and I can put you into have him get on and come into this meeting by Zoom, and then put the two of you in a chat room by yourselves. Okay. All right. And you're agreeable to this matter being conducted by Zoom rather than in-person hearing? All right. You're agreeable with that, Mr. Wagner? All right. So the defendant is charged with 3 counts of aggravated trafficking, methamphetamine, and 3 counts of aggravated possession. All third-degree felonies. The matter is set for a trial on May the 9th. It's the first pre-trial, final pre-trial is coming up the 20th. Mr. Holt has been presented with a plea of guilty form, which indicates you're going to withdraw your not guilty plea, plead guilty to 2 counts, counts 1 and 3. I'll just hold that up to the camera so you can see the first page. That's a little bit dark here. It's dark up here. Can you see your name there in the plea guilty form?
Yeah.
Okay. And then on page 3, there are signature lines. And just not quite halfway down, there's a sentence on page 3 that says, I enter this plea voluntarily. And right below that looks to me to be the signature of Donald Holt. So I'll hold that up to the camera. And is that your signature there by that X? And when did you sign this, Mr. Holt? Last week? All right, and out there at the jail?
Yes, sir.
And was Mr. Wagner there when you signed it to answer your questions and go over with you?
Yes, sir.
And do you feel that you had enough time to fully consider that decision before signing the agreement?
Sure.
And since you did that last week, today's Monday, the 11th of April, you still want to go forward today with this plea agreement? All right, and did you enter into the agreement to plead guilty voluntarily? All right, now the agreement states that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 3, aggravated trafficking methamphetamine under 2925.03A1 of the Ohio Revised Code, both third-degree felonies. States you understand that the maximum penalty in each case could be 36 months in prison. The minimum would be 9 for a prison term. And then different levels in between. It goes from 9 to 12, and then every 6 months up to 36 months. And there's a fine of $10,000 available, a mandatory fine of $5,000, possible license suspension of 6 months to 5 years. And this says the prison term mandatory.
It is your honor.
Oh, because of the juvenile.
Because of the 2 prior,
Oh,
two
okay.
prior drug convictions.
Oh, okay, gotcha. All right, so that means that the prison term is mandatory, so there can't be any community control or probation. You have to serve whatever sentence is imposed because of the previous history makes it a mandatory prison term. You understand that? Are you, now under the law, if you plead guilty to both charges, you can get any sentence between 9 months as a minimum concurrent on the 2 charges up to a maximum of 72 months, the maximum of 36 months on each count consecutive. So the range is possible from 9 to 72 months, maximum fine of $20,000, and a mandatory fine of $10,000 total on the two charges, plus license suspension of 6 months to 5 years. I mean, you understand that? Excuse me. All right. Now, are you facing any felony charges in any other jurisdiction? Are you currently on community control, probation, post-release control, or parole for a felony? Okay, well, you should know if you are. Okay, all right. Now, under the law, if you are convicted of these offenses and serve a prison term, which, well, actually you have to serve a prison term for the penalty. Once you complete whatever term has been imposed by the court, the adult parole authority could decide to put you under post-release control supervision for a period of up to 2 years. It's optional. They don't have to, but they may. But again, it's up to them, not the court. And if they do, you'll be supervised in the terms they set. If they decide that you have failed to comply, they can return you to prison, even though you served the entire term of the court order, for a period of up to 9 months for one violation, up to maximum of half of your prison term for all violations. But if your violations do felony, then an additional whatever sentence the judge in due case to impose on you, that judge is also authorized to sentence you. In this case, is authorized to sentence you to an additional period of 1 year or whatever time for remaining on the post-release control or committing a new offense while under post-release control in this case. And if that occurs, that sentence has to be served consecutively with the sentence in the new case. You understand that? Amen.
Mm-hmm.
This monitor here is really dark. I don't know what's going on there, but it may need adjustments and say put in that new control lines. I don't know.
Okay.
I just noticed it when I was looking at it a while ago. I couldn't see it, but it's all right on this one. Yeah, I turned it off. I was talking to my neighbor. Yeah, not a problem. I'm having a little technical problem here. I was just talking to him about it. Yeah, no problem. I'm glad you were paying attention. All right. Now, the charge in count 1 alleges that on or about July 23, 2021, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in an amount equal to or exceeding bulk amount less than 5 times bulk amount. That you previously convicted of 2 felony drug offenses, illegal manufacture of methamphetamine, a second-degree felony in Clinton County Common Pleas Court, case number CRI 16-500-327 on January 17, 2016, and trafficking in marijuana, fourth-degree felony in Highland County Common Pleas Court, case number 85 CR 75 on February 27, 1986. The violation section 2925.03A1. And count 3 alleges the same language except that it occurred on July 28, 2021. Now, Mr. Holt, you understand what it is you've been accused of doing in those 2 counts? What the state said you did, when or how they alleged you did it? I'm sorry, you do? Okay. Now, have you discussed the nature of those charges, the evidence of the case, the possible legal issues of the case, the possible defenses you might try to raise at trial, possible outcomes of the trial with your attorney? Are you satisfied with his advice and confidence in this matter? Have any threats been made against you to plead guilty here today? Are you under the influence of any types of drugs or alcohol at this time? Now on page 2, there's several lines printed in bold and underlined. I'll read those as follows. Defendant shall enter plead guilty to count 1 and count 3. State will dismiss remaining counts. State and defense joint recommend 18 months mandatory incarceration on count 1, consecutive to 12 months mandatory incarceration on count 3. Defendant agrees to repay fine money to Highland County Task Force in the amount of $660. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today? Now, under the law, the matter of sentence is up to the judge, not the parties. So even though there is a recommendation from both parties as to what the sentence should be, I'm not bound by that agreement. So once you plead guilty, if I decide, after I heard all the evidence and information presented, that's not an appropriate sentence, I could sentence you to as much as 72 months total, fine you $20,000, $10,000 mandatory, suspend your license for 6 months, 5 years in each count. You understand that? All right, now, do you hold any license or certificate from any state agency that regulates any profession or occupation? You have certain constitutional rights, which understand, Mr. Holt, before I can accept your plea. First, you have a right to have counsel, Mr. White, who is appointed to represent you, not simply work this case out, but provide any defense that might be available to you under the law that you'd like to provide. So if you decide that you do not want to plead guilty, but you want to defend against these charges, he'll still represent you, including trying the case, if that's what you want. You understand that? Now, under the Constitution, you have a right to have a jury trial in this matter, in which a jury of 12 people would be selected from a group of citizens that live in this county, who are summoned for jury duty on your trial day. After they are selected, the evidence will be presented, they will be instructed on the law, and then that jury will decide by unanimous verdict, meaning all 12 have to agree on whether the state proves your guilt on either or both of these charges. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means give up the right to have a jury trial. In that case, you have what's called a court bench trial, which means that instead of a jury hearing the evidence, it would be the judge who hears the evidence. The judge would apply the law, the judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. You understand that? Right now, under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you to cite the state. So if you have witnesses you're uncertain are going to come in voluntarily, your request for it is a court order that's called a summons or subpoena. And that forces those witnesses to come to court and be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that? Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make that decision, and if you decide not to testify, the fact that you did not testify cannot be used against you in any way, by anyone, at any time in the proceedings, and in fact, no one's even allowed to talk about it, except in one situation, and that is if there's a jury trial, and you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that? Now, under the Constitution, you are presumed innocent of these two charges until proven guilty by the state of Ohio on every essential element of defense charge. So what that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any defense in your, any evidence in your own defense at all at trial. You may, but you're not required to. But whether you do or not, the state is required to present evidence that proves to the jury or the judge, depending upon which type of trial you'd like to have, of your guilt by proof beyond reasonable doubt on every essential element of the offense charge in each count, which is the highest burden of proof that's known under the law. You understand that? Now, originally you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and exercised or invoked all the rights that I just described. You can change your plea, not guilty to guilty, that's the opposite of not guilty plea. Guilty plea admits the allegations in the indictment, admits that they're a crime, so you committed that crime. That plea waives gives up all of the rights that I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty, waives gives up the right to have a jury or a court trial. Waives gives up the right to confront witnesses against you and to cross-examine through your attorney. Waives gives up the right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. The waives gives up your privilege against self-incrimination because you're saying you're guilty, and that's what you use to find you guilty. It waives gives up your presumption of innocence because if you say you're guilty, the state's not required to prove that you're guilty. It also subjects you to being sentenced immediately by the court, which is what's proposed here, which is likely to happen. And finally, it waives gives up any right to file an appeal, which you could have had up until this point in the case. Now, if I were to sentence you to a maximum sentence or under certain circumstances to file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. You understand all of that? And are you a U.S. citizen, Mr. Holt? All right, now, do you have any questions about the charges or the possible penalties? You understand them? Have any questions about the plea agreement? You understand it? Have any questions about the constitutional rights I've explained? You understand those? Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today? You understand that? Now, is there anything you need to ask Mr. Wagner about before we go any further? You have any questions about anything that I've explained to you here today? All right, then this is your decision. Withdraw your not guilty plea, and plead guilty to counts 1 and 3 pursuant to the terms of the plea agreement that we just went over. All right, then as to the charge in count 1 that alleges on or about July 23, 2021 in Huntington County, Ohio, you didn't knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount and less than 5 times bulk amount. She had previously been convicted of 2 felony drug offenses, illegal manufacture of methamphetamine, a second-degree felony in Clinton County Complex Court case number CRI 16-500-327 on January 17, 2016, and trafficking marijuana, a 4th-degree felony in Huntington County Complex Court case number 85075 on February 27, 1986, violation of section 2503A1 of the Ohio Revised Code, a 3rd-degree felony carrying a mandatory term of between 9 and 36 months in the instance provided by law, fine of up to $10,000 in each count, mandatory fine on each count of $5,000, and possible life suspension on each count of 6 months to 5 years. How do you plead? All right, as to count 3, which alleges the same thing, except alleges that it occurred on July 28, 2021, but otherwise the exact same language that I just read to you. How do you plead? All right, thank you. Court finds that on this date of the court, the defendant was advised of all his constitutional rights, and a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Pleas accepted and ordered filed. Defendant is found guilty of counts 1 and 3 as set forth in the indictment. Counts 2 and 4 to 6 are dismissed. Now, inasmuch as these are mandatory sentences required by law, there's not a request for a pre-sentence investigation. The court doesn't see the reason to provide one, but request one, I should say. I'll go ahead and proceed with sentence. King, you have to say.
Only one contained in the plea agreement, Your Honor.
Wagner?
Your Honor, we asked the court to follow a recommendation that the state and myself have come up with. Obviously, the court clearly be concerned because of the priors. I've asked the court to consider giving my client credit. We were here at the first pre-trial. Once presented with the discovery of the case, Mr. Holt was not difficult at all. Basically, JD can investigate can. That's why this case was moving along at the speed that it has, Your Honor. Again, I've been out to see Donnie. He's obviously getting a little bit older. I mean that respectfully to him. He's walking around with crutches out there. Again, Your Honor, we just asked the court to follow the recommendation. That's all, sir.
All right, Mr. Holt, anything you'd like to say? All right. It is a judgment order of the court, defendant B is hereby sentenced to a mandatory term of 18 months on count 1, and a mandatory term of 12 months on count 3. Those sentences are ordered to serve consecutively to each other for a total of 30 months. Defendant is granted 38 days of jail time credits for arrest on March 5th, is that correct?
Sounds about right, sir.
All right. Which as of today is 38 days. You're also ordered to pay the court costs of judge grant execution order. If you have to do that, that can be collected from various means, including the levy of bank house wages, earnings, or other assets you may have. That doesn't collect it, then upon completion of the prison term, then the court order you do the service give you credit for each hour you work, and hour set by the court, each hour you work, reduce your credit by that amount until paid in full. All right, now, upon completion, and the court orders the sentence to be served consecutively because the sentences were conducted or committed as part of one or more courses of conduct, and that the seriousness of the harm of the 2 offenses will automatically be reflected in a single sentence, and the sentences imposed are not disproportionate to the nature of the offense and the harm caused. And the defendant's criminal history indicates that the second sentence is necessary for protection of the public, and the parties have recommended that. Now, upon completion of these prison terms, Mr. Holt, it is possible the adult control authority will put you under post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, you can supervise on the terms they set. They determine that you have failed to comply, they can return you to prison, they can serve an additional period of up to 9 months for any one violation, up to a cap of half of the prison term, which would be half of 30 is 15 months. But if you commit a new felony while you're in post-release control in this case, then in addition to whatever sentence the judge can impose in that new case, that judge could also sentence you for committing that new offense while under post-release control in this case to an additional period, 1 year, whatever time left on the post-release control, whichever is greater. If that occurs, that has to be served consecutively sentenced in the case. The court also orders you make restitution in the amount of $6,600 to the Huntington County Task Force, and that payment will be made through the victim witness restitution escrow account. That is a substantive order, means that it can't be discharged in bankruptcy, and you could be required to come back to court if you fail to make payments on that once you are released from prison. All right, is there anything further, counsel?
Just so the record's clear, the restitution is actually $660, not $6,000.
Oh, I'm sorry, $660. I said $6,600, didn't I? Yeah. $6,660, not $6,000. Yeah, okay. All right. Anything further? All right, thank you. All right.
Did you want to do Mr. Winters, Judge?
Yeah, what about Hatfield? Is he in custody?
That's
okay.
First of all,
My other one for Wednesday, he's that guy who's supposed to get a letter from mom and he can come to the house.
Yeah.
He wanted to post a monetary for 500.
Oh, this was just a bail review then, wasn't it?
I'm not sure.
we had the bail review on either Thursday or Friday, Thursday of last week.
Oh, okay.
And he wound up posting as opposed to me getting a modification with mom's permission. So he posted.
Oh, yeah, I don't know what happened, it's not set till April 13th. I must have jacked it off the wrong file. All right.
I'm in. Coach, your Honor.
Yeah. All right, Mr. Winters? All right, this case number 19 CR 210, State of Ohio versus Dennis Winters. Mr. Winters is appearing by Zoom from the jail. Record reflects that he was placed on community control for aggravated possession of methamphetamine on September the 1st of 2020. Then there was an additional entry filed on January the 4th of this year. The probation department filed a notification actually last week that you had failed to comply with the terms of the community control. They alleged that you violated Rule 7 and that you were administered a drug screen on April 4 while incarcerated at Greenfield Jail, tested positive for methamphetamine, buprenorphine, and fentanyl. Rule 15, you are liable to $20.50 for made no payment. And you have violated Rule 19 and failed to complete recommended aftercare. Now, you're entitled to have an attorney that represents you, and did you fill out your financial disclosure form, Mr. Winters?
Yes, Your Honor.
Well, I'm going to go ahead and point one for you and set the matter for hearing because I don't have a probation officer here today. I'm not in a position to go forward. So the court will appoint Ms. Witt to represent you, and set this for hearing. Let's see here. There it is. April the 21st at 10 o'clock, or I mean at 1 o'clock. We'll notify your attorney of appointment to be held without bail until that time. All right, thank you. Is that everybody else, Joe? Now?
Yes, sir.
All right. All right, Seth, I. All right, case number 22 CR 33, State of Ohio versus Seth L. Eimer. Attorney on behalf of the state is Mr. Prosecutor King. Attorney on behalf of the defendant is Attorney Jacob Widener. Are you Seth L. Eimer?
Yes, Your Honor.
All right. Mr. Eimer entered pleas guilty. Count 1 and 2. Count 1 being trafficking marijuana under 2925.03A1, they took your felony. And count 2 being aggravated trafficking methamphetamine in the vicinity of a juvenile under 2925.03A1 as well, a third-degree felony. The court referred the matter to the probation department for a pre-sentence investigation. I have received that report, reviewed it, and each of the attorneys had an opportunity to review a summary.
State has your honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was in favor, so you will make your honor.
$320 restitution is to
County task force.
we're going to add that to the plea agreement. I'm writing it in today. It won't be shown in the record downstairs if anybody checks the hard file. And I'll put today's initials, or date, my initials to show that I'm the one that put it in there. All right. Mr. Wagner?
Thank you, Your Honor. Go ahead, stand up, sir. Your Honor, we asked the court to file a recommendation of state. When this case began, Your Honor, Seth was in my office fairly quickly after he was indicted. At that time, he was already through his own accord at FRS doing counseling. Actually, he and his wife came down and met with them. And again, I've been in constant contact, if not weekly, at least every other week with him or his wife checking up on him. He was going to FRS. Something happened there, either through illnesses or unexcused absences. He on his own accord before I even got on him. He got enrolled in Soda Pink Valley. So he's doing the FRS counseling or already counseling in Soda Pink Valley right now. He's working in Goshen. So he's got a lot on his plate. But again, Your Honor, I can only say if it's an indicator as how his probation will go. He's Johnny on the spot at my office whenever I call him. He's there within minutes. He's even very accessible to his wife or himself. Looks like he's here with family. Your Honor, we're asking the court to take, I'll say, not for necessarily a leap of faith, but to give him the opportunity to continue what he's doing, continue working, continue treatment, being with his family, and
Right, or anything you'd like to say?
Just that I'm sorry and I'm trying to make a better life for me and my family.
Well, the time the probation report was listed, we were still at FRS, and then I just got the facts on the 8th, Friday, from Soda Pink Valley. Said you were there on April the 6th, and diagnosed with stimulant use disorder and cannabis use disorder, and they're going to be in outpatient treatment once a week. What was the reason you left FRS?
I was sick and I missed a couple of days. And then I didn't have an excuse though for all the 4 days that I missed. She only got an excuse for 2 days, so she told me that I had to restart group, which it was quicker for me to get into Soda Pink Valley than it was to get back to FRS.
Well, one of the things about Soda Pink Valley is program is only once a week, and makes me wonder if perhaps you just were missing and got booted out, decided to go there so you wouldn't have to go as much. Because here's what I'm looking at. You've been in outpatient recovery before 2020, successfully completed it, administered court. You were back in that as of February the 9th after you got charged on this. And then I look at your history and you have a lot of misdemeanor offenses, no penalties, but a lot of misdemeanor offenses. And a lot of probation. And my concern is I'm not certain that once a week is going to be enough for you. But at this point, well, actually, here I'm looking at, you know, I thought I'd read this and I just found it, that you had cases in municipal court in 2018 on line 518, and then 2 more on 10/2/18, in which you were put on 2 years of probation and were unsuccessfully terminated on December 23rd, 2020, which means I guess they just gave up. You tested positive while under pretrial supervision, in this case, for alcohol as well as marijuana. You're still on supervision in another case from April the 6th of 21, and this would be a violation of that, so I don't know what might happen in that case. But, you know, it appears here that you have some issues in terms of doing what you're supposed to do. I see here 2 warrants for shoplifting from Kentucky, one out of Fayette County from 11/4/21, which I believe is Lexington, one out of Harlan County. I'm not sure where that is for shoplifting. Both of those are misdemeanors. That was on August the 2nd of 21. So, yeah, I think that very skeptical you're going to be able to stay clean. But it is your first felony offense, even though that 3rd-degree felony gives me authority to send you to prison on a first offense. I'm going to give you an opportunity to prove that you're going to be able to do this. But what you're going to have to do is you're going to have to quit using drugs. And if you think that you're going to just get by once a week and beat a problem, I don't think that's likely to happen. But at this point, we'll give you that opportunity. So, it's your word of court to be sentenced to a term of 3 years of community control supervision under the supervision of probation department. Under these conditions, you obey all laws and all jurisdictions, conduct yourself in all honor and manner at all times. Report when and as directed, be truthful in all statements you make to the probation department regarding your conditions. You must keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission, and you must have a copy of that written pass with you when you're out of state. You may not enter upon the grounds of an correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. Now, because of your conviction, you're prohibited under both federal and state law from purchasing, possessing, owning, using, or having under your control any kind of firearm, ammunition, or dangerous ordnance. If you do so, that would be a violation of the felony under both state and federal law subject to prosecution. It's also a condition that you not have any of those items while under community control in this case, nor any other weapon of the type. You're not permitted to purchase, possess, use, or have under your control any type of controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, or any instrument device you think may be used to administer them or prepare that administration. Unless you have a copy of that that's lawful, and you must provide that within 24 hours. You're to submit to drug testing when and as requested. Just in case you get the right idea, some of my probationers have that they will get a medical marijuana card. You're not permitted to have medical marijuana. But honestly, it's a scam. It's just a way for the state to raise money. It's kind of like alcohol. They're taxing it. Now, some people that smoke pot, it's not a problem. But when they smoke pot and sell it, then they start doing other things like you have, it's a problem. And then it just becomes a means of self-medicating to avoid dealing with your substance use disorder. So the treatment specialist and all of the training and education I've had regarding drug court and people dealing with sobriety is that medical marijuana cards are a big problem for people in treatment because it's just self-medicating. Be like if we just let you drink, that's what you can't have any alcohol, nor may you be present in places where they're sold to, even if it's otherwise lawful. You are not to associate with anyone who is a co-defendant in this case, if there was anyone, or any other person has a criminal record, a member of a gang, or any other criminal group that could or has influenced you to commit a criminal offense or to violate these conditions. And that applies to any family members that fall within that definition unless you're living with them immediately before this offense. You are not, or you must report any conviction, citation, or other charge of violating the law not later than the next business day after that occurred. Then provide your supervised officer financial information records so your ability to pay any fees costs to be reviewed. Now, if you are referred by the probation department for an assessment or evaluation for any further type of treatment, therapy, counseling, training, or educational programming beyond that ordered by the court, you're to submit to that. They tell you that you have to undergo any kind of treatment or therapy. If that includes residential treatment, that you are to enroll in and successfully complete that program. You're to pay the court costs of this action and make payment arrangements to do so with the clerk. You're to pay restitution through the victim witness escrow account. And let's see, what was that amount again?
$320.
All right, $320 at the rate of $50 a month, beginning July 1st of this year. And every first on before the first month, each month after that. And that will be payable through the Huntington County Victim Witness escrow account. And you are to pay any service fee that is charged for that service. And the court costs are also be able to pay as a substantive order if you fail to make payments or otherwise pay those. And the court can collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. That doesn't collect it, then the court authority to do your service, give you credit for each hour you work, and an hourly wage set by the court. Each hour you work, reduce your credit by that amount, they'll pay in full. Now, in the event that it's alleged that you have failed to comply with these conditions, well, I don't know, did I say that by being placed in control, you're consenting to serve without a warrant? If not, I'm going to go ahead and say it again, just to be safe. By being placed in complete control, rather than being sentenced to prison, you're deemed consented to search without a warrant. The person, residence, vehicles owned by you, used by you, or any other property places under your control where you're found at any time, by any supervised officer or any other officer of the probation department. Now, in the event that probation fails, appeals that you have failed to comply with these conditions, they will file a written notice after the clerk. You'll be served a copy. The court will set a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your control and sentence you to prison between 6 and 48 months and fine you up to $12,500. If that occurs, then once you complete the prison term imposed by the court, the adult control authority may put you under post-release control supervision for a period of up to 2 years. They don't have to, but they may. If they do, you'll be supervised on the terms they set, and in the event that they find that you have failed to comply, then they will have the authority to return you to prison to serve an additional period of up to 9 months for one violation up to a maximum of half of your prison term for all violations. However, if your violation is a felony, then in addition, whatever sentence the judge in a new case imposed upon you, that judge is also authorized to sentence you in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentenced in the new case. You're also ordered to pay the mandatory fine of $5,000. To be paid within 3 years. If you don't have to pay within the 3 years, then your new control could be extended. And let's see, that will go to mandatory drug enforcement fund of prosecutor and.
I'll have to check the breakdown because it just depends on the agencies that were involved here.
Okay.
A portion of it would go to task force, a portion would go to Hillsborough Police Department was also involved in this case, a portion would have to go to them, a portion to the prosecutor's office.
All right, submit an entry then, specifying that.
You say $5,000?
$5,000 is a mandatory fine for and 3 to be submitted by state. All right,